A very warm welcome to everyone who's watching the video and everyone who's going to watch the video today, tomorrow, maybe in the future. A very warm welcome. And the video that we're making today is on something that I observed in the court earlier this week, and I thought मुझे इस पे video बनाना ही है because when we start early in our career as advocates, we witness a lot of things that I feel like need to be addressed as well. So everyone who's watching, I need like you could also understand what I am saying, where this is coming from, and you could also tell me if I'm saying something wrong or correct me if I'm saying something wrong. So earlier this week, मेरा एक मैटर लगा हुआ था in the district court, and hence I had traveled for the same. Now the cause list. A cause list is one which is basically the list of cases that one court will take up in that particular day. So I saw the cause list. My matter was pretty low in the serial number, and hence that gave me a lot of time to sit down in the courtroom and understand what other cases were taken up and how they were going to proceed with. As a beginner, मैं तो बोलूँगा ये सबसे best चीज़ है because I get to witness what the other cases are going on. I get to understand how they've been taken up, what are the cases that have been dealt with, and to be honest, freshers के लिए just in the career, they just like it to be in the courtroom, hear what is happening. You gain a lot of perspective. So that is very good. Now, one of the cases that was taken up, which got my attention as well, was whereby the plaintiff was granted a stay in the instant case, and the defendant was opposing to the stay as well. But the judge asked the junior in the case for the plaintiff side, where the main counsel was. From the plaintiff side was the junior, and उसके साथ एक intern था, and the main counsel was missing. So that's the question that arose from the judge's side as well, where the main counsel was who had filed a wakalatnama. So the junior says that the main counsel hasn't been keeping well, and hence we wanted an adjournment. The defendant side's advocate says that this has been the case from the previous 3 hearings, and we cannot go on for this from a very long time. The judge agreed, says that please get your advocate. If she isn't really keeping well, they could have informed us and come via a virtual hearing, because this is a physical hearing and we understand they could have, just taken up the matter in in virtual hearing, and they could have come. To which the junior says that it's okay, all right, sir. What I'll do for you is I'll just get him in the later stage. How about you give me a password, please? So the judge then asks, if it is the instant case that you're saying that they are not keeping well, how are you sure that you're going to get a passover and you're going to produce them? To which she says that she's going to get someone from the office who also has her name filed in the wakalatnama. To which the judge agreed, and the judge says, I don't have a problem, but I see that this has been something which has been prolonging, and hence if the same has not been produced in the next 1 hour, if your main counsel isn't really here in the next 1 hour, I will then impose cost on you. The next 1 hour, nobody is produced, no counsel is there from the plaintiff side, and hence the judge imposes a cost of 5,000. Being a junior, the advocate gets a little GTG, saying, so please do not do this, please help us understand if we've done something wrong, but we'll make sure that the main counsel is there on the next date. You could give us a short date and make sure that the counsel is there. The judge even then goes on to impose a fine of 5,000, which is more or less justified. 2 hours later, the main counsel is then now present in the court, who says, sir, I am here. I am very sorry for what my junior or the intern had said in the court earlier, and hence they did not have a proper knowledge about what had to be said and what not to, and hence we very sorry. Please recall your order, or if any has been passed by you. The judge says, since you're here, your junior had actually said a lie to us that you've not been keeping well, and hence we impose a cost on you of 8,000. Now, the case is, this particular person, this advocate from the plaintiff side, goes on to say that this junior had no clue of whatsoever was going on. The intern had no clue, basically throwing the intern and the junior associate under the bus. While we see that this has become a very common practice these days to just throw someone under a bus who's junior, but the court acknowledged the fact that it was the main counsel who was lying to the court and not the junior who was there to lie. She was the one who was coming on the instructions of the senior or the main council. So there is very, very no nexus that could not have been made. So the judge in that instant case then gave a penalty of 8,000 bucks because of non-appearance in the instant case. Now they could have gone for above also, and to me it is very justified because if you're not appearing in your own case for 3 4 hearings, how are you even justifying it to your client? Irrespective, do not throw your interns, associates, junior associates under the bus because you've done something wrong. Own up to it because you didn't want your 5,000 bucks to go in vain. You just can't say anything for your junior associates or the intern. Those people were trying to protect you and for your act because you didn't want to go to the court. Understood that you were busy or you might be busy, but just come up with a better understanding or a reply to the court. And that's pretty much it. I mean, I don't know what other people think, but then blaming the juniors for something that you could have done is just wrong, plain simple wrong. So that's pretty much about it. And let me know what you feel like because we've interned and we've seen how things have been. And recently, the Allahabad High Court had also taken up the matter whereby the MACT tribunal, that is the Motor Accident Claim Tribunal, had also charged intern who had acted on the advice and thoughts and directions of a lawyer to represent in the MAC tribunal. But the MAC tribunal had said that it was impersonation on part of the intern and hence an FIR was registered in their name. Now, in the Allahabad High Court, the FIR was quashed or stayed, but then what was not really sure was how are the interns then treated. The interns and juniors are not at all treated well if you come to think about it because in the courts you just sending them to do what you do not want to do. So at the end of the day, juniors understand that you are an advocate on your own. You're going to be in 3 4 years practice on your own. So understand what is going to be good for you, what is not going to be good for you. Independently, you're going to be soon practicing. You've got to go have your name too. Do not just blatantly say something that has been told to you to say. So that's about it. What I wanted to say.